I now call upon Shri Kapil Sibal to exhibit his awe-inspiring grandiose speech.
Chairman of the Vivekananda Institute of Professional Studies, Dr. S. Siba, Vice Chancellor, Vivekananda Institute of Professional Studies, distinguished members of the faculty, distinguished guests on the dais, young students present here, my friend in the media, ladies and gentlemen. The two most indisciplined professions in this country today are law and journalism. So how can you request everybody to be disciplined? It's a dream come true for me to be here. Because when I was a young student, I never had access to the kind of institution in which you are studying here. Access to the latest technology, access to information in the palm of your hand, and through that access, empowerment. We used to seek empowerment through our teachers because they were the sole repositories of knowledge. But in the 21st century, the sole repository of knowledge is not the faculty anymore. Because students have access to so many forms of knowledge, multifarious, diverse, endless forms of knowledge that they can access. So technology has brought about a paradigm shift in the way we teach and the way we learn. And so, in a sense, the opportunities that our children have today are much greater than the opportunities we had. But at the same time, the responsibilities of our children are much greater than the responsibilities we had. And perhaps one of the most important professions in the country today are the profession of law and the profession of journalism. Because both of them are in a sense interlinked. I would say that there is an umbilical cord which connects the profession of journalism and the profession of law. You'd ask me why. Let me tell you. What does journalism involve? I'll take journalism first. When you go out to the world and you become a journalist and you investigate a story, what are you required to do? The first thing that you are required to do for a responsible journalist is to investigate the facts. That's very important. In the absence of facts, there can be no responsible journalism. So how do you investigate the facts? In order to investigate the facts, you need to know something about the subject. If you are investigating something about the environment, you need to have domain knowledge about environment. If you need to investigate about a story in law, you should have had domain knowledge in the law. If you want to investigate something about science, the Chandrayaan, the launching of the Chandrayaan, or something in biotechnology, you need to have some domain knowledge of biotechnology. But very few journalists really worry about domain knowledge in the 21st century. And the reason for that, especially in the context of electronic media, is that you need to carry the news 24/7 and instantly. It's like instant coffee. You need a story, it has to come about instantly through the electronic media. There is no time to understand the intricacies of domain knowledge with reference to the story that you are carrying forward. And therefore the result is that many stories carried in the absence of domain knowledge are likely to be inaccurate. This is not so in the print media. The print media, journalists have enough time to investigate the facts and to investigate a particular story and bring those facts to the consumers who read your stories. But having investigated the facts, what is your story supposed to do? What is the ultimate objective of journalism? And therefore there is a link between journalism and law, which I will come to later. But what's the ultimate objective of journalism if you carry a story forward? If you investigate a story and write about it. What you need to present to the people and to the public when they read the newspaper or when they see you on the electronic media through the anchor or by yourself, you need to inform the public objectively about the facts. That's very important. Therefore your story has to be balanced. Your story must reflect both points of view. Your story cannot be biased. Your story cannot be with reference to a particular agenda that your channel, your anchor, and the business house who runs the particular channel might have. And therefore there's a very difficult balance that each journalist has to ensure when he investigates and takes a story forward. Remember this, that you are, especially in the electronic media, being viewed by millions of people throughout the country. 1.2 billion people is the population of this country. And the media has access to millions and millions of people, especially the vernacular and the regional media. So in a sense, your story will hugely impact the minds of millions of people. It will be a game changer. You are the source of knowledge, and therefore what you put out in the story will tend to change the opinions of people one way or the other. Therefore, you are at the center of the information revolution. You are at the center of forming an opinion and help others form an opinion. You are at the center of bringing knowledge to the doorstep of millions of people. But that must reflect an element of objectivity and balance, which alone will ensure that you will be a respected journalist as you go into society. What happens in the law when you pass out, and I believe 5 batches have passed out from this institute, and you become a lawyer? What is your first responsibility when a client comes to know? Many clients will come to you and they will be unclear about the facts, just as a journalist is unclear about the facts when he starts investigating a story. Lawyers will also be unclear about the facts, and the client himself does not understand fully the facts that he wishes to present to you. It's your responsibility as a lawyer to not just understand the facts, but to analyze the facts, just as you do in journalism. And once you understand and analyze the facts, then you have to collate them in a form of a petition, just as a journalist collates them in the form of an article which is printed in the newspapers. And once you collect them in the form of a petition, it is those facts that you present to the court. But there is a difference, because the facts that you present to the court may be objective from the point of view of your client, but may otherwise be fully subjective. That's the difference between the journalist and the lawyer, because the lawyer represents the case of his client. The journalist represents the case of the entire public. So when you present your case in court, you present your case through the eyes of your client. But make sure that the facts that you state to the court are truthful. Because you cannot afford to state a fact which is erroneous in court, because the day you do that, the judge will lose confidence in you as a lawyer standing before him, and the next time you appear before his court, he will not trust you. So it's important for you to actually state the facts truthfully before the court from the point of view of your client. Then, of course, the counsel for the other side will place his facts before the court. And then you will argue your case. And the end result will be reflected in the judgment of the court. But what is your responsibility as a lawyer when you argue your case? Your responsibility as a lawyer is, one, to present the facts correctly, to argue your case for your client passionately and with conviction, and understand and state the law in the context of the facts that you have understood. I'll give you one piece of advice for all the lawyers, all the young lawyers who are sitting here, or all the young students who are aspiring to be lawyers. The law will emerge from the facts when you understand them. When you go to a court of law, remember this, that it will, the way you present your facts will have a huge impact on the court. And the court, if he or she empathizes with your client, will actually modulate the law depending on the nature of the empathy that you are able to evoke in the heart of the judge. Therefore, when you go to a court of law, emphasize the facts and be truthful about the facts. Even if some of the facts are against you, it doesn't really matter. And then the law will automatically fit in. That's the first principle you must follow as a lawyer. The second principle you must follow if you want to be a successful lawyer is that you must make sure that you know more than your opposite counsel and you know more than the judge. That's very important. Remember, power of information is everything in life. Information means power. So if you are better informed than anybody else in court, you will be far more powerful than anybody else in court, and you are likely to succeed in your case. So study the law before you go to court and be more informed about the law than the judge and the opposite counsel. Study the facts much better than the opposite counsel. And remember, each one of you, when they go to a court of law, have more time to study the facts and the law than the opposite lawyer, because the opposite lawyer will be a seasoned counsel who has been in law for many years, and he has less time to study both the facts and the law, and therefore young lawyers are always at an advantage over experienced lawyers. And therefore have faith in yourself, be convinced about your own. I'll give you a little example, and I haven't told this story to anybody. Let me share this story with the young people. I was a young lawyer, 26, 27 years of age, and I started practicing in the Supreme Court. And I was a briefless lawyer, like most of you will be when you go to the bar. And then one day, a young man from Haryana, belonging to the constituency of Mehan, came to me. He was a young man who was around 28 years of age. And he said to me, "Sir, I have a case in the Supreme Court. I just fought an election from Mehan. I won my election. But after I won my election, the opposite candidate filed an election petition against me, alleging corrupt practices against me. And I have lost the case in the High Court. Now I have to come to the Supreme Court. Will you be my lawyer?" So I was a bit surprised, because normally election petitions are argued by lawyers who have at least 15 years standing in court. So I had no standing in court, and I was surprised that he had come to me. And I asked him, "Why have you come to me?" He said, "Sir, I heard you one day in some court arguing a matter, and I liked the way you argued, and therefore I have come to you. But there's another reason why I have come to you." I know you are a briefless lawyer, and I am also briefless because I have no money to pay. So I said, fine, that's a good combination. I said, don't worry about the money. Remember this is a very important lesson. Never worry about money when you represent a client. Very important. So I said, no problems, I will argue for you. The brief ran into about 2,000 to 3,000 pages. It was a big brief, and the matter was in the Supreme Court, and I had never argued in the Supreme Court in a regular case. So I was very worried, because these judges are judges of great experience, great knowledge. They are the repositories of law. And so I was a young man, 26, 27, didn't know much about the law. But I studied very hard. And I prepared the case in such a manner that by the end of it, I almost knew all the 2,000, 3,000 pages that were in the brief. So lo and behold, one day the matter came up in court, and the opposite counsel was the Advocate General, then sitting Advocate General of Haryana, who had come to the Supreme Court to argue the case. And the bench was the following. It was presided over by Justice Palekar from Maharashtra, Justice Bhagwati, your very famous Justice Bhagwati, P.N. Bhagwati, who became the Chief Justice of the Supreme Court of India, and Justice R.S. Sarkaria, who was again a very famous judge. So these were the three judges. And very interestingly, I share this with you because I haven't shared it with anybody else. One of the issues involved in the case was that this young man, this client of mine, had allegedly paid a bribe to a person to withdraw his nomination paper after he had filed it. And it was proved that he had actually given the money and that that gentleman had withdrawn his nomination paper. And under the Representation of People's Act, if I remember correctly, under section 123, one of the Representation of People's Act, which is titled as bribery, if you bribe a candidate, your election can be set aside. And so because the facts were proved that he had bribed the person who filed the nomination paper, he lost. And he lost not on just this one count, but he lost on 6 other counts. So on 7 grounds his election had been set aside. So as soon as I stood up in the Supreme Court, Justice Bhagwati said to me, young man, who are you? So I gave my name. He said, young man, we don't need to hear this case. I said, sir, but this is a first appeal because the court of original jurisdiction was the High Court and the Supreme Court is the court of first appeal. So I said, it's a court of first appeal, you have to hear me. He said, young man, you don't know the procedures of this court. We don't have to hear you. You have to satisfy us if there is anything at all in your case. I said, okay. So I spoke for about 45 minutes without reference to any brief. I did not refer to any pages in any brief, but I orally presented the case for 45 minutes. The third lesson, always know your brief backwards. You should not refer to your brief when you are arguing a case. You should be so well prepared. So anyway, at the end of 45 minutes, the presiding judge said, Mr. Sibal, you are right. We will have to hear this case at full. So I started arguing. The moment I started arguing, Justice Bhagwati intervened. And Justice Bhagwati said, young man, I find from the paper book that your client has given a bribe to a person who filed his nomination paper. And this is covered by a judgment of mine that I delivered just before the vacation 2 months ago. And because it's a covered case, there is no need for you to argue further. We will dismiss your petition. Are you aware of my judgment? I said, yes, I am aware of your judgment. So what do you have to say? I said, sir, your lordship, your judgment is wrong. No, they were taken aback. How can a young man at the age of 26 dare to tell 3 judges of the Supreme Court about a judgment that Justice Bhagwati had delivered 2.5 months ago to be wrong. So, to cut the story short, I argued the case. It went on for 20 days. And when the judgment came, Justice Bhagwati wrote a separate judgment saying that his judgment was wrong. And it's a reported judgment. This is how I started my career. So the 5th lesson, believe in yourself. If your heart tells you that what is right, do what is right. Don't worry about the judges and don't worry about the other counsel. Follow your heart. Follow what your conscience tells you. And when you do that, you will always succeed. But unfortunately, I still lost the case. Though I won on the law, I told you there were 6 counts on which the judgment had been set aside, the election petition had been allowed and the election had been set aside. I succeeded on the law, I succeeded on 4 other counts, but I lost on 1 count. I felt very sad. And I was very despondent. Many years later, many years later, Justice Bhagwati met me. And he said, yeah, because by that time I knew him very well, because at that time I was a regular practitioner in the Supreme Court, and he said to me, young man, you should not have lost the case. So I said, sir, if I should not have lost the case, why did I lose the case? He says, you know, this was Justice Palekar's last sitting in court. He was presiding over the bench. And Justice Palekar told us, how can we encourage these ayarams and gayarams, because after your candidate won the election, he joined another party. This was nothing to do with the merits of the case. So he said, we cannot encourage people who are not moralistic, and therefore we should not allow this petition. I said, sir, but the law was in my favor and the facts were in my favor. So Justice Bhagwati said, you know, this was Justice Palekar's last judgment. We did not want a dissent. And therefore, we agreed with Justice Palekar and you did not succeed. 6th lesson, you sometimes win or lose a case without reference to the law or the facts, because it is the judges who ultimately decide. Therefore, don't get worried sometimes even when you lose the case. It really doesn't matter. This is the story of my first case in the Supreme Court. Now, let's talk about journalism, because I've given you some lessons that you must follow in a court of law. In journalism, remember, just as a lawyer and you have information in the palm of your hand, that information can be used and misused. And that information does have the tendency to destroy reputations, whosoever's reputation you touch. So you, in fact, are holding that information in trust. And when you use that information in any possible way, you can destroy the careers of human beings, and you have destroyed the character of human beings wherever they are. So use that information very carefully. And if some of you have read the provisions of the Constitution, Article 19 of the Constitution gives you the right to freedom of speech. But the freedom of speech is tempered by Article 19(2) of the Constitution, which says it is subject to defamation, it is subject to contempt of court, it is subject to security of the state, it is subject to public order. These are the exceptions in the Constitution for free speech. But what I notice in the media today, that none of them follow the exception. None of them follow the exception. People's reputations are being destroyed on a daily basis without reference to defamation, and without reference to other attributes which protect, which are necessary when you exercise your right to freedom of speech. So remember, as a journalist, when you exercise your right to freedom of speech, make sure that you do not destroy people's character and reputation, because that gentleman whose character and reputation you destroy has no recourse, because the processes of the law are such that it takes 15 to 20 years to have a defamation case decided, and therefore there is no defense of the person whose reputation is at stake. So this is a very important lesson to learn when you practice the profession of journalism. And I dare say that perhaps these are the two most important professions that are in this country. You go anywhere in the world, the leaders of nations in the world belong to the legal profession, if not to journalism. You are the leaders of tomorrow. And this is a profession, not a business. And unfortunately, both journalism and law is no longer treated as a profession, it is treated as a business. This is most unfortunate. I'll give you a little story about journalism, because I've given you a story about law, but I'll give you a little story about journalism, which is also with reference to freedom of speech, how we fight for freedom of speech. Because we are the ones who protect freedom of speech in courts of law. I have never ever stood against a person to curb his right to freedom of speech. And remember, each one of you must protect that very important constitutional provision of the freedom of speech of our citizens. Well, the story is the following. And you will remember this, way back in the 90s, you had no television which showed cricket matches. In fact, the uplinking facility was provided by Videsh Sanchar. That was the uplinking facility that was provided. And we wanted to televise a cricket match taking place in Calcutta. And the Calcutta Cricket Association came to me saying that the authorities in the government of India are not allowing that cricket match to be televised because they are not giving the uplinking facility. So I appeared for the Calcutta Cricket Association of India in the Supreme Court of India, and I said that the government cannot deny the Calcutta Cricket Association uplinking facility through its agent to televise the match so that millions of people can see the cricket match in Calcutta. And do you know what the government said at that time? The government took up the defense that airwaves belong to the government. It's something I have never heard of. How can airwaves belong to any government? Airwaves are free, just as water is free. Can anybody say that water belongs to me when it is flowing? Whatever I breathe within my lungs is mine. Whatever is not within my lungs is yours. So how could Government of India take a position like that? So I argued before the court that this proposition that airwaves belong to the Government of India is unthinkable and violative of Article 19 of the Constitution, which is freedom of speech. And ultimately, the court held, and this is for the journalists here to know, the court held that airwaves do not belong to the government, and that is the first time that a match was televised through an uplinking facility so that millions of India could see. That brought about a revolution in the television industry. And thereafter, the court held that an uplinking facility is only a facility. It can't control the airwaves. And what the government can do is freedom of speech. And you lawyers must fight along with journalists for freedom of speech. But remember this, there is a Lakshman Rekha there as well. And I tell my journalist friends sitting here to remember that Lakshman Rekha. Don't get carried away by the enthusiasm of your own agendas. Don't get carried away by the agendas of other people. Today, just as the profession of law has become a business, freedom of speech has also become a business. And I want to share this with you. Freedom of speech is now commercial speech. It is not free speech. Because your free speech depends on the number of advertisements that you get and the money that you earn from your advertisements. That in turn depends on the number of TRPs you get. And so your freedom of speech agenda is in fact, because of the TRPs that you get, it is no longer free speech but commercial speech. And when you go out in the world of journalism, protect the freedom of speech, fight against commercial speech. And we go out in the profession of law, protect freedom of speech. Never compromise on that. India is a democracy that will be alive only if we protect the freedom of speech. Not just your own speech, protect the freedom of speech of others. Even if there is one naysayer in the country, protect his right to free speech. That is the only way that democracy will survive. And that is why we are a vibrant democracy. If you have noticed in the last several months, despite all that is happening in the media, the government has not moved to curb anything because we want to protect the freedom of speech. But we are still waiting for the time when the media channels and the electronic media realizes that the meaning of true freedom of speech is to present before the people of this country a balanced view that in fact states the facts of any issue objectively, whether it's before the court of law or before the court of the public. And therefore, the arena is absolutely the same. You need to project the right, the objective facts before the people of India, either through the court of law or to the general public. And as long as you adhere to that principle, namely doing and discharging your duty consistent with constitutional principles, you always will be successful. Remember, the greatest leaders of India were lawyers. Mahatma Gandhi was a lawyer. Jawaharlal Nehru was a lawyer. And I can name you hundreds of leaders. Motilal Nehru was a lawyer in the profession who actually were at the forefront of the freedom movement. The 21st century has huge challenges. And whose challenges will be taken up by the lawyers and the journalists. And you will be the leaders of tomorrow. As long as you exercise your duties, as long as you exercise your rights with as much fervor, with as much passion with which you exercise your duties, India will continue to be a vibrant democracy which will be a beacon to the rest of the world. Thank you. Jai Hind, Jai Bharat.